May it please, Lordship. I'm sorry.
From the daily list, item number 1.
What is he mentioning?
Yes.
It's a full bench matter?
Yes, my Lord. Because I have filed a miscellaneous application yesterday with a copy to others also, my Lord.
This matter?
Not this, number 2.
No, wait. Wait for a minute.
Yeah.
Perfect.
So that.
Only 3 cases are there.
Yeah.
You can wait.
Lord, that matter has not been listed. That is why mentioned.
You can ask your junior to represent if you have got any other matter.
Yes, my Lord.
Out of the 4, 3 are here. So, yes.
Lord, the status of the transportation of coal
Yes.
is at page 5, my Lord. Kindly see page 5 of the status report filed on 30th April 2023, my Lord.
Status report dated?
Report 30th April, my Lord. It was filed.
Yes.
Yes, my Lord. And kindly come to page 5, my Lord. Sorry, page 2, my Lord. Page 2.
Page 2.
Page 2. There are 4 districts where the coals have been inventorized, my Lord. First is South Garo Hills district, my Lord. Transportation of re-inventorized coal. Transportation of re-inventorized coal from pithead to the designated depot is complete in South Garo Hills. Therefore, any coal is found lying outside the designated depot, it shall be treated as illegally mined coal, which shall be seized in an action shall be taken as per section 21 of the MMDR Act. So, 1 district is, my Lord, completed, my Lord. Now, West Khasi Hill district, transportation of re-inventorized coal from pithead to the designated is complete in West Khasi Hill district. Therefore, any coal found, my Lord, so then West Khasi Hill also is complete, my Lord. Now, Southwest Khasi Hill, my Lord. In respect of Southwest Khasi Hill, the total re-inventorized coal was 289,660.454 metric ton, out of which only 5,260.77 metric ton lying outside the designated depot, as no one has come forward to claim the said coal. Hence, the steps will be taken to seize the coal, and same will be disposed of in accordance with section 21 of the MMDR. Now, the problem area is, my Lord, East Jaintia Hill district, my Lord. In respect of East Jaintia Hill, till the last date of hearing, 1,34,608.662 metric ton remain to be transported because of owners were not approaching the state for issuance of transit, and it was decided to take over the coal and transport by the state government. It is most humbly submitted owing to various exigencies related to parliamentary action and less availability of transport vehicle. To transport the coal from pithead to designated depot, only 64,291.002 metric ton coal could be transported, and presently 70,317 metric ton coal is to be transported. My Lord, next page, my Lord, page 4. The concerned official of the state had a meeting on 26 April 2024 with single-member committee of Honorable Justice Kataki, appointed by this Honorable Court, and committee has directed the state to conduct inspection as to the existence of the exact amount of coal lying on the original coordinates of inventorized coal. And if the coal found to be there as per inventorized list, same may be transported to CIL, designated depot, or any temporary depot which is under the custody of government. Committee has directed the exercise to be completed within 15 days. Efforts are being made to comply with this direction, my Lord. So this is the status with regard to transportation of coal, my Lord. Now there are other directions which have been issued by Justice Kataki regarding in 21st report, my Lord. 21st report, Justice Kataki has made certain recommendations before this Honorable Court. And we had a detailed meeting with Justice Kataki, and we are acting on those recommendations also. 21st report also records that we are acting on those. If your Lordship will see that there are 2 sets of recommendations below. If your Lordship will kindly see page 4, where recommendations are there.
For the 21st interim report. Of the report.
Report 21st, because this is the state 21st.
21st report, not
21st report. 22nd report we do not have, my Lord. That copy has not been.
Which you do not have?
This is the latest report which has been filed by Justice Kataki. I have 21st interim report. 21st report. Actually, 28. 28.
Yes.
My lord, so as per the 20th interim report, my lord, and then thereafter, my lord, we have taken certain actions. And if I can take your lordship to the report first, so that this is a report dated 12th March. Your lordship has the copy of 12th March report, my lord.
Yes, 12th March.
Yes, my lord. So kindly see the status report first, my lord, and then thereafter, your lordship may see the directions, because we have called out the directions in our report, and at the same time, what steps we have taken, my lord, that we have mentioned in our report only, my lord. For the sake of convenience, my lord, kindly see page 5 of my status report dated 30th April. My lord.
Your status report.
Yes, my lord.
Dated 30th April.
Yes, my lord. That the 21st report also made recommendation on seizure of illegally mined coal and its disposal, which is simultaneously being monitored by committee of honorable. So the committee affirmed the following factual position. At present, Southwest Kasi Hill district, at present total 34.735 metric ton seized coal is available in the district, for which application has been filed before concerned court, and order is yet to be obtained for disposal. My lord, because this is an offence under section 21, so it will go to the concerned magistrate for permission for
As per the judgment of the Supreme Court.
as per section 21 of the
Yes, as per
MMDR Act.
section 21 only.
Yes, my lord. So West Khasi Hill district, a total quantity of 1,39,886.43 metric ton coal seized under the provision of MMDR Act, and district has been auctioned off, which is now being lifted and transported by auction purchaser. So we have, my lord, auctioned 1,39,886.43 metric ton as per the order of the learned magistrate, my lord, and now it is being transported. Because in respect of these coal, my lord, entire proceeds come to the state government. Because these are all, this will not go to the illegal miner, because only those coal, my lord, which have been saved by our Honorable Supreme Court in the order of 3rd July 2019, there we have to pay them. After auction, we have to pay, we deduct 10% MERF charges, and then we have to. But so far as auction of these coals are, the entire money comes to the coffer of the government, my lord. Now, East Gentile, my lord, at present, one of the lot of coal which was recently seized yet to be auctioned off due to reconciliation of mismatch, as reported by Deputy Commissioner of Magistrate and recorded in the FIR by the police authority. Exact quantity of coal seized has been found to be 7,502.6953 metric ton, and prayer for disposal has been made before competent court and order. So these are various steps, my lord. I will not bother your lordship, which we have taken. Now, your lordship, kindly see other recommendations at page 7, paragraph 6.
Yes.
This is Justice Kataki has recommended, my lord, audit of MEPRF, Meghalaya Environment Restoration Protection Fund, my lord. Which whatever coal we are auctioning, my lord, certain amount goes to this fund, my lord. Justice Kataki has recommended a meeting has been convened by Secretary Mining and Geology Department to finalize the selection of auditors for auditing Meghalaya Environment Protection and Restoration Fund, and has taken decision to recommend appointment of GAP and Associate to audit the ME, since the member found that firm is an experienced firm and has quoted the lowest rate. Proposal is now being forwarded to Oversight Committee for approval in its next meeting, my lord. If I take your lordship to the events, my lord, the NGT is also monitoring the auction of these coals. NGT also appointed, my lord, Oversight Committee headed by Additional Secretary of Government of India. So, so far as fund aspect is concerned, that is being monitored pursuant to the order of the Honorable Supreme Court and NGT, my lord. Now, audits of source of coal from coke oven plant, ferroalloy plant, and thermal plant. Insofar as coke oven plants are concerned, as observed by the committee, except two entities, Gentia Co. Private Limited and Abhi Co. Private Limited, have deposited the royalty and cess amount as demanded. Above two entities have questioned the so-called notices and respective replies, and after scrutiny, the replies have not been found completely. So we are taking the action in accordance with law with respect to Gentia Co. Private Limited and Abhi Co. Private Limited, my lord. Now, then the issue was also setting of integrated check gates, because movement of coal takes place through those check gates, my lord. And at the foot of the page, at page 8, my lord, As observed by the committee, 10 smart check gates have already been set up by TCI, is a Government of India undertaking law, and taken over by state government and have made operational under the supervision of the state government. Now, status of the coal mining, Milord. In respect of the 4 applications who have obtained previous approval of grant of mining lease from Government of India and whose mining plan has been approved by Ministry of Coal, Government of India, environmental clearance from the concerned authority is yet to be accorded. A state expert appraisal committee is presently scrutinizing each individual project, and the process will take 2 to 3 months, Milord, so far as environmental clearance is concerned, Milord. Now, there are issues with regard to the coal pit, Milord, closure of pit, illegal pits which were there, Milord. For that, CMPDIL has been gone. The closure of pit heads and abandoned mine is an environmentally friendly manner and require better exercise. Therefore, project is being undertaken in collaboration with Central Mines Planning and Design Institute, a Government of India company, which has prepared a draft conceptual report for closure of abandoned mines, and same has been approved by the state government. The state government thereafter has requested CMPDI to prepare detailed project report now for closure of all mines, and once DPR is approved, the same will be forwarded to Oversight Committee for sanction of funds from MEPR for implementation of the project. Now, the drone survey was also there, Milord. Drone survey after the coal is transported, then we have to check whether any coal is lying outside the pit head or not. In compliance to the recommendation, state government has called proposal for some firm which have forwarded to the Oversight Committee constituted by Honorable NGT for approval and utilization of ME for exercise. Further, the observation made by this Honorable Court order dated endorsing such recommendation has also been forwarded to for the expeditious approval is awaited, Milord. A report on action, Milord. This was a Don Bosco matter where the matter is still pending, Milord, but we have seized the coal and Section 21 proceeding has been initiated. There was some news report also, Milord, at Roman 8. Alleged incident of death of 3 minors and injury to 12 minors in illegal coal mining in Muriak village. This incident reported in Shillong Times was investigated by Deputy Commissioner and Superintendent of Police and was found to be hoax news, and no such incident has been found to have taken place, Milord. May I also inform this court, Milord, that today also Principal Bench National Green Tribunal, Milord, has taken up suo motu based on this news article, and that matter is also listed before NGT Principal Bench, Milord. And this is the status of Milord. So we are taking steps, Milord, and we are working in close coordination with Justice Kataki. Justice Kataki has been monitoring, and whatever recommendations are being given, Milord. Now we are almost end of the tunnel, Milord. Light is now visible. We can finish the entire task also, Milord, so that we can start from clean slate. And any coal found outside, no.
That's what we were passed order last time.
Yes, Milord. That order was there. So this is this. And there is a latest report which we are not privy to it, Milord, that the report has to, so then we can take action. 22nd report should be there.
Yeah, 22nd report.
Okay.
22nd report, yes. We'll furnish you with the 22nd report. You take the
Yes, Milord.
copy of the 22nd report.
Yes, Lordship has been recorded.
We'll record your submissions made by you. And
Yes,
also the status report filed by you dated 30th April.
Yes, Milord.
This is with regard to East Jayantia Hills.
The problem area.
In fact, the
Problem is in the East India Hill only.
also they have given.
Yes, ma'am.
Justice Kadaki has given a
Figure 70,000 metric ton.
70,000. Yes, yes.
On 26th April, there was a meeting held by Justice Kataki of this month, last month.
Somebody is appearing.
But with other matters.
Not in this matter.
They are in the second matter, my lord. Chat.
Their video. Jyoti Moore.
Yeah. The other matter, my lord, not in the
Is in second matter.
second matter, my lord.
Well, when the matter is taken up for hearing, Advocate General produced the status report dated 30th April 2024. Wherein drew the attention of the court to the various steps taken with regard to curbing of illegal mines, and that insofar as South Gaurav Hills and West Kazi Hills are concerned, action will have to be initiated under Section 21 of MMDR Act 1957. Insofar as Southwest Kazi Hills district is concerned, out of 289,662.544 metric tons of coal, 5267.77 metric ton is lying outside the designated coal depots, and that no one has claimed, and that steps have been taken to seize the coal to be disposed of in accordance with the Section 21 of the Act mentioned supra. Insofar as East Jaintia Hills District is concerned, till the previous hearing, a total coal of 1,34,608, 1,34,608.662 metric ton remain to be transported, and that none has approached for obtaining transit passes, and it has been decided by the government to take over the coal and transport the same. Full stop. We'll further submit that at present 70,317.66 metric ton coal is left to be transported. We further submitted that the committee has directed that within 15 days there should the direction should be complied with. Stop. Advocate General submitted that they are acting as per the directions of the Kadaki Committee, Justice Kadaki Committee, and that as per the 21st report pertaining to seizure of illegal mine coal and its disposal, the steps taken and the factual position has been narrated in the status report in para number 5. To take this para number 5. To further submit that a meeting was convened by Secretary Mining and Geology Department to finalize the selection of auditors for auditing the Meghalaya Environment Protection and Restoration Fund within bracket MEPRS. And that the proposal has been forwarded to the Oversight Committee for its approval in next sitting. You would further submit that insofar as the ferroalloy plants are concerned, show cause notice have been issued to 7 units and that the decision will be taken within a period of 1 month based on the reply that is going to be submitted. It stated that 4 applicants have obtained previous approval for grant of mining lease from the Government of India, and the same has been approved by the Ministry of Coal. The State Expert Appraisal Committee is scrutinizing the individual product for proposal, and that it will take another 2 to 3 months for finalization. They also submitted that the drone survey and the videography, as stated by this court, is also strictly adhered. And the observation made by this court, dated 14/3/2024, has been forwarded to the Oversight Committee based on the, if further submit, the Advocate General further submitted that there is an alleged incident of death of 3 minors and injury to 12 persons when there was an illegal coal mining in Muriap village, which has been reported in Shillong Times, and based on the news report, a tribunal, NGT, no?
This, Milord, this Long Times published this.
No, which NGT has taken step.
The NGT has also taken note of.
NGT has taken suo motu action based on the paper report. According to Advocate General, the committee's recommendation and the orders of this court have been duly but strictly complied with, and that based on the 22nd report, which is yet to be submitted by to them, they will act to ensure that there is illegal coal mining is completely eradicated. Or no, don't put eradicated, curbed. And that he has not received a copy of the report.
Yes.
Registry's director forward a copy of the 22nd report to the Advocate General in order to enable him to file a further status report the next date of hearing. When do you want?
After 4 weeks.
1 month, 2 months like that?
Yeah, after 6 weeks, you know.
After?
4 weeks or 6 weeks, whatever is.
1 month, no? Post on today is 1st June, no? 1st May. 1st May, today or 1st May. We post on 3rd June?
3rd June.
3rd June. Copy of the report to be furnished to all the parties concerned.
This before NGT, my lord, it is OA 479 of 2024. News item titled Illegal Mining Activities Claim 30 lakhs. I'll put it.
Incorporated. NGS is taken and number is also pending. Yes.
Item number 2.
Yes. Your friend said that he has filed an application.
I have filed an applications, miscellaneous applications regarding clarification from this court, my lord.
Regarding?
Some clarifications, and my lord, I have been allowed to trade, my lord. Now I have been restrained, my lord, by, your lordship will kindly see what the PIL is about. Well, the PIL is about regarding the extraction
The
of...
application is listed now, today?
Not there on the list.
No, my lord, that is why I have mentioned to before your lordship, my lord.
Not listed.
So we
You have
have
a copy?
I received a copy yesterday, last evening.
issued, I have given all the copies to them.
To file an objections. Same date.
My lord,
Prepared by the council so and so. The miscellaneous application has been filed. The same is yet to be numbered. The council for the respondent in the application would submit that he has received a copy.
I'm for the
Yesterday.
petition.
he is for the petitioner, I am for the respondent.
In the application. Received a copy of the application, respondent in the application
Yes,
said.
I am sorry. I'm sorry.
Yes,
So your lordship has been fixing the matters and
same date.
well, there will be a urgency case because of, well, your lordship will kindly see what has happened, Milan, in this case, Milan. I am a trader, Milan.
No, we'll hear you.
No, my lord, your lordship, there is a restraint, Milan, restraint orders, Milan. There is a restraint orders, Milan. I cannot trade, Milan.
Let the final objection, sir. Thereafter we'll hear the matter.
Definitely, Milan. But
Final objection within 2 weeks.
well, a short bit may be given because of this, Milan. There is one of
Once the objection is filed, if I mention, we'll advance a hearing. You must understand that, see, while you oppose it, 3 of us will have to sit.
my lord.
Yes, yes. The 2 weeks expected to file objection.
Item number 3.
Some obliged.
Three.
Again, my lord, illegal coal mining, prayer 14, my lord, kindly please.
So we're going to go along with that matter.
Yeah, my lord, lordship is already monitoring in this motor matters. These matters have got,
We'll pass a common order.
yeah.
We'll pass a common order.
What is the petitioner?
Huh?
Petitioner, there's nobody here.
And there's nobody
The
here.
petitioner.
Nobody is appearing, my lord, and this is, has got no bearing, my lord. These are all in personal and private interest litigation, my lord. Kindly see prayer 14 also.
Page 14.
Page 14, prayer, my lord. General and omnibus direction has been sought, my lord. A writ in the nature of mandamus shall not be issued directing the state.
1 minute, sir.
I'm sorry, page 14, my lord. PIL number 1 of 23, my lord.
Petition even.
Yes, my lord, petition.
Wait, nobody is here because of public interest litigation. So we can't dismiss it on the ground of non-appearance in PAL.
What I was saying, my lord, is that these matters are unnecessarily pending.
Page number 14.
Yes, my lord. Issue directing the respondent to seize and stop the export of illegally mined coal from state of Meghalaya as coal originating from outside state of Meghalaya through South Garo Hill.
They are also participating in the Karaki.
Yes, they can go before justice. Your lordship may dispose of with the liberty to that they can.
In the previous case, we passed orders on another matter.
Earlier, my lord, if I can place that order, that order was there where your lordship has given the party to implement.
They can also be an intervener.
Yes, intervener.
Yes, of course. Why come
So,
so?
why should there be so many public interest litigation?
I'm on the same issue, my lord.
Can you give a copy of the order?
I'll do that, my lord. That was passed separately. There was an order passed in the other.
We passed order. This bench just passed an order.
Yes, your lordship. I will
During the last year, if you have a copy, we'll pass orders.
because that order is in the separate writ petition, my lord.
And separate petition, we know
Separate
that.
petition. I'll place the order before the court, my lord.
Similar order will pass. Same order in the other case. Take that order and say that The present petition is identically placed to that to the one in PAL number so and so, giving liberty to the writ petitioner to be an intervener in that case, who has been suo moto added as respondent in the writ petition. As an intervener and put forth all the submissions available, all the legal and factual submissions available to him, factual and legal submission available to him. The disposal of the issue is already pending before Justice BP Kadagi committee. It is open to the petitioner also to participate before the Kadagi committee and put forth his submissions. Without prejudice to rights of the parties, this PAL is closed, giving liberty to the petitioner as stated supra.
Now, my lord, third PIL is fourth, my lord, sir. These first
PL2 or I don't remember.
PIL2, my lord. Yes, I will please.
Must be PL2.
Yes, my lord. Then Champner PIL8.
The PFL.
Earlier case. What is the case number? The earlier case of which you disposed of?
Yes, sir. Like the
Where is that?
upstairs, sir. Disposed.
The disposed of? What is the number?
Case number.
Check, sir.
Anyway, we'll get the we'll give a copy so that we can pass over.
Item
But
number 4.
petitioner is not here also.
Yes.
Item number 4.
But what is the purpose in how many public authority in the same?
One matter is being monitored by your lordship and they are multiplied on the same. Item 4 also, if your lordship will see prayer of item 4 also, my lord.
Item?
Item 4, my lord. Champer M. Sangma.
But your friend is also not here. What's the problem?
The petitioner is in this case here, my lord. He is here present before your lordship.
Where is he? The other case.
Other case, my lord. Because he has lost interest in page 65 is the prayer, my lord.
65.
Yes, my lord. The prayer is as to why appropriate action efforts have not been made by the respondent authorities to implement management, regulation and operation of way bridge in the state of Meghalaya and their failure to comply with the provisions of Meghalaya installation, regulation, maintenance and operation of way bridge rule 2009 as amended date, and failure to carry out effective check and maintenance of record with the trucks, vehicles and after.
But this is not with regard to
Because what they say, my lord, what is being said by them, my lord, that the check gates are important tool to check the illegal coal mining, my lord. And your lordship has seen in 21st report of Justice Kataki, Justice Kataki has noted that 10 smart check gates have already been established, my lord. So this transportation regulation, all these issues are also before Justice Kataki. If your lordship will,
this issue is
also Justice Kataki has given
Kindly
recommendations.
just submit, my lord. If lordship is pleased to peruse the order passed by this honorable court on 27th of September, my lord.
27th of
September 27/09/2023. But before that, my lord, lordships are pleased to see
1 minute,
the first-
27?
Yes, 27/09/2023,
oh,
my lord. The state's case is, my lord, that the matter is infructuous because the matter is.
of the PL1 appears serious anomalies of function which we usually see the petitioner given liberty to ascertain and negate deficient. We'll hear this matter. We'll hear it. We'll hear both the matter. We don't want to close it.
Maybe taken up on after 2 weeks along with the second item. And if I may also point
In the
out,
light of the order dated 27th September 2023, we are of the view that uh, this PAL 8 of 2023 will have to be heard along with PAL 1 of 2022.
one of 22 has already been disposed of, my lord.
One is disposed of, my lord. It can be heard with the suo motu PIL, my lord.
Along with the
What is the number?
PIL 2 of 2022. Yes.
PAL 2 of 20
22, my lord.
to be heard along with PAL 2 of 2022. Yes.
Orders already passed. Orders already passed. Number 3.
What, Mr. Sharma? See, you can see also identify this other PAL is pending. You are entitled to go and make your representation before Karaki committee and also be an intervener. We will permit you to address argument in the suo motu PAL. How many PAL can be on the same issue?
We have filed. We have already filed our reply, my lord. But I don't know in which matter.
They never replied. They never replied. No rejoinder.
But anyhow, this is a issue connected with the suo motu PAL. Exactly. Mr. Sharma, we will permit you to be an intervener, make all your factual and legal pleadings in that suo motu PAL. How many matter? 5 or do you mean to say 5 or 6 PL to be entertained on the same issue? So in the process, we will not be in a position to dispose of the matter. Suppose we dispose of one matter, any adverse observation may affect the other case. So we will give you liberty. We will give you liberty to be an intervener. You are entitled to make your submission before Karaki committee and make all your submissions available, legal and factual submission available to you before this court. We have already made you as a respondent suo motu. Yes. Yes.
Item number 4 of the main list, Millard. I pray for some time, Millard, in this. On account of some personal, it's an appeal against a conviction. Millard.
What is it?
Number 4 of the
1 minute. 4 of main list.
main list.
Criminal appeal.
Criminal appeal.
What is the matter about?
So it's an appeal against a conviction in a murder case.
302.
302 million. I will some accommodation it may come up after some couple of weeks.
It's a murder.
Whatever.
How many accused?
Accused. There are 3 accused who have been convicted.
All the 3 are here.
Well,
Sudden provocation?
sorry, what?
Sudden provocation? Or predetermined?
We'll take that plea also now.
You make it a point, then we'll reduce it or acquit, that's all.
Well, I'll do my best with it. After a couple of weeks, I'll do it. On account of some personal difficulties.
Yes, at the request of the appellant. What's the matter? May 1st, no? 15th.
Right. Declare. Yes, we'll take it.
From supplementary list, item number 1.
Please, Lordship, my apologies. Lordship, I'd like to mention item number 5, Lordship.
Item number?
5, Lordship.
Why the same list? One adjournment means everyone will be starting.
My apologies, Lordship. The Penalty Council is our station, Lordship.
What is this?
There's a possible matter, Lordship, conviction of 20 years, Lordship.
After the amendment.
Lordship.
Age of the victim?
The victim is 13 years, Lordship.
Person? Accused?
Accused.
You also stated in 313.
Lordship, I just received the paperwork 5 minutes back, Lordship. I'm very apologize.
Oh, it must be available in 313, no? It must be there.
Yes, Lordship. "31 years, Lordship."
31 years.
Chip.
Love affair. Is it a love affair?
Pardon?
Is it a love affair?
Lordship, I'm not sure of that 31 years and 13-year-old girl, Lordship. I don't think so. That could be a
13-year-old girl, huh?
yes, Lordship. 31.
No
The
possibility.
accused is 31, and I don't think so. There
possibility.
could be any love affair.
Hey, what is the position he was holding? Teacher, uncle, Stepfather.
Lordship, if your Lordship can give me some time to go through the brief, I'll.
Yes, we'll post it on 6th. You argue on 6th.
Watch.
Argue on 6th. Six, we don't know. We may go up to. I have it on 9th.
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 Watch.
Argue the matter. Yeah.
From supplementary list, item number 1.
Hello, oblige.
I am appealing for the respondent on behalf of Mr. S. Setia, Senior Assistant Income Tax Department, Lordship. Lordship, today he is out.
You are appealing for the respondent.
So kindly. Yes, Lordship.
Who is appealing
On
for
behalf of
who is
Mr.
appealing for the
S. Setia.
appellant?
Well, I am paying for the petitioner, my lord.
Petitioner, yes.
My lord, since he has expressed some difficulties, my lord, about his senior, my lord, and he's taken my consent also, my lord.
Consent of whom?
It may taken up on Monday.
Consent of whom?
My consent here yesterday he expressed some difficulties, my lord. Respondent, my lord.
I am for the respondent.
Today, 4 years, 6 years. Reopening. Or the income
No, my
tax.
lord, it is regarding, my lord, recovery of income tax proceeding, my lord, pending appeal, my lord. My appeal is pending, my
That
lord.
is right. It
Hearing has
was
been concluded.
appeal is pending.
Appeal is pending before the Commissioner appeals, my lord.
Ah.
And my appeal was filed 2022, my lord. Till that, the appeal has not been decided, my lord. In the meantime, my lord, the income tax
Then
officer
how
has
is the
initiated
recovery
recovery proceeding, my
maintainable?
lord.
When you prefer an appeal, you cannot ride 2 horses at the same time.
No, I'm not challenging the order, my lord. I'm just praying for direction to decide my appeal at the earliest, my lord.
1 minute.
And till then, my lord, my lord, this is
1 minute.
proceeding, my
Where
lord.
is your prayer? Where is your prayer?
My lord, I'm coming, my lord. My page is page number 13 and 14, my lord.
13 and 14. See, there are provision under the Income Tax Act for the appellate authority to grant interim order. You cannot say, High Court should pass an interim order and make the appellate authority non-functional. He cannot usurp
No,
the
the
jurisdiction
appellate-
of the appellate authority. He has got powers. I think you will have to deposit for 25% of the amount, is it not? To
My
prefer.
lord, what I'm praying, my lord, hearing was concluded on 16/4, my lord.
Sir, have you,
Till 1
sir, you have
2020,
preferred an appeal in time.
my lord.
Have you deposited
In time.
Have you made the precondition deposit?
My lord, that amount has not been deposited, my lord. But my lord, one thing is there. Hearing was concluded on 1/8/22, my lord. My appeal was heard on 1/8/22, my lord.
Who is appealing for the income tax department? Who is appealing for the income tax
I am
department?
appealing for the. Lordship, I am appealing for on behalf of Mr. S. Setia, Standing Counsel, Income Tax Department, Lordship.
So
Today he is out of station, Lordship.
No, we will direct the appellate authority to decide the matter within a period of 4 weeks.
Lordship, matter may be kindly taken up on Monday, Lordship.
So what is it, sir? We are directing the authority to decide the matter within a period of 4 weeks, that is all. Till such time, no coercive action be taken.
Lordship.
Lordship.
What is it?
Lordship.
Lordship.
But have you deposited? Is there any precondition deposit? Mr. Jyoti, any preconditional deposit under the act?
Lordship, I have at this stage I have no instruction, Lordship.
Sir, we are asking about the provisions of the act. There are no instructions.
Manoj, if I may assist your lordship. Under the Income Tax Act, one of the provisions, there is no statutory pre-deposit. There is no statutory pre-deposit. There is a circular issued by the board which says that the authority will consider the stay application and when in such certain circumstances will not direct more than 20% deposit. Now that 20% deposit is considered as a normal, but statutorily there is no mandate.
Not like VAT, not like VAT.
Not like VAT or GST or service tax or excise.
What you want to know? We'll decide them to decide.
Please.
Present writ petition has been filed for the following relief. The petitioner confined his relief that the appeal has got to be heard at the earliest point of time. But there is a rider stating that no coercive action shall be taken till the disposal of the appeal. Full stop. We are not inclined to pass any order on merits except directing the appellate authority to decide the matter in accordance with law within a period of 2 months from the date of receipt of the order, after affording an opportunity to the petitioner. The petitioner disposed of.
My lord, still there no coercive action taken, my lord, please, my lord.
They will
My
not do
limited
it.
prayer, my lord.
They will not do it. When the appeal is pending, they will not take any coercive action, sir.
My lord, they have issued notice. Lords will find notice at page 99, my lord.
Page?
Page number 99, they have issued recovery notice, my lord. Page 99, my lord. That's why I've come before your lordship, my lord.
What is the amount? 13 lakhs. How much is it?
I didn't cover, my lord.
What is the amount? 13 crores or 13 lakhs?
13 crores, my lord.
13 crores.
13 crores. And my, otherwise, I'm not liable to pay tax. I'm exempted under section 1026 of Income Tax Act, my lord.
Yes. We don't want to say anything at all. Yes.
My lord, some protection, my lord.
No. Let the appellate authority decide.
I can number three.
Otherwise,
Yes.
May please your lordships. This is an appeal.
Paper book.
Not yet, my lord. This is a motion statement.
Is it a offence?
Offence under section 302, my lord.
302.
Lordship, only thing there are 6 accused and they filed one common appeal.
Sir?
There are 6 accused,
Ah,
so only one common appeal has been filed.
what is wrong?
No, nothing wrong, but
What is wrong in that?
eventually, if they are taking a chances, it's up to them.
Huh?
They are taking chances because if they can segregate that, what was the different role of the accused, and the evidence has to be appreciated differently. Otherwise, you'll be binding on all the accused. They can
Then
take
you let them file at the time you address argument.
it's up to them because it's in the motion stage. They can, it's still curable.
All the 6% are preferred an appeal. Huh?
Yes, my lord.
But I want
What is
Common judgment, my lord.
Huh?
And common judgment, common incident, also same incident, my lord.
We'll see. Only procedural. What is it? When the writ petition, when there is a petition for to file jointly, it's not available. You can use it. Discretion 482 is there.
absolutely.
Let them file. Yes. Yes.
My lord.
Paper book within 1 month.
Yes, my
weeks.
lord. Yes, my lord. 1 month. Lower court records may be called for, my lord.
Yes. Please.
Highly obliged.
Item number 3.
Number one. May it please your lordship. Appeal for the respondent, assessee, my lord.
Yes, sir.
My learned friends appeal, my lord.
My lord, this is a tax matter, my lord. We have come against the order passed by the state.
Is the order?
Against the order passed by the Central Excise Tribunal, my lord, Calcutta. My lord, the last occasion my friend is raised an objection with regard to the mentality of the appeal, my lord. And I have sought instruction from the department, my lord. I was requesting for some time, my lord, today, my lord. In fact, even I was told by my colleagues that my friend is not coming. So that also I
My lord,
didn't.
we had checked with him, not once, on 4 occasions, then only I have come, my lord. He's come from Bombay, I have come from Delhi, my lord. Lordship, may I look at the order of the tribunal? Forget my objection. Overrule my objection, look at the order of the tribunal. Pure finding of fact.
It was a little surprise for me because I was told that they are not coming, my lord. My lord, if it's taken up tomorrow also, my lord, I can.
Persons have come from other places. One from Bombay, one.
My learned friend, Manoj's local colleague here, had checked with their office not once but 4 times. We had checked. We have no objection if they inform in advance, Manoj. But when we come here and then they make this objection, Manoj, and this is a statutory appeal against it's for admission. Look at the tribunal's order, Lordship, to just look at the tribunal's order, Manoj.
Well, we can stay back for till tomorrow. Maybe we can do it tomorrow, my lord.
Can't expect them to wait also.
I think this Ceylon is a good place now. They can stay for one day.
That is right.
Lordship, may just see the tribunal's order, my lord. And look at the questions that they have framed, my lords. Everything will become clear, my lords. Pure finding of fact. And it's an issue relating to valuation. They themselves have framed the question saying that whether the value adopted is correct or not. And that your lordships have taken a view sitting in Madras, my lord, the division bench, saying that questions relating to valuation, classification, rate of duty, all have to go to the Supreme Court. Not only that, kindly have a look at the tribunal's order. The tribunal refers to one decision of the tribunal in the case of Jyoti Limited on same issue and follows that. Against Jyoti Limited, they went to Supreme Court. They went to Supreme Court. And the Honorable Supreme Court, Manoj, by speaking order, dismissed their appeal saying that these are pure questions of fact. I'll just hand over a copy, Manoj. No copy. Sorry.
Mr. Boshia, what is there?
Absolutely nothing, Manoj. Lordship, may kindly see that?
But I'm a little caught unaware today, my lord.
It is his appeal, Manoj, not mine.
Well, that's okay because there's a little bit of traveling also, my lord. But we can have it tomorrow, my lord. Tomorrow I'll come prepared, my lord.
Tomorrow your friend is not here. That's a problem.
They can appear online also, there's no problem. Whatever I have, my lord, I'll take instructions from the department, I'll place there. My friend is a tax expert, my lord.
We have also taken a view here in the review petition.
But that was a review petition, my lord.
Yes, Manoj. That order is also at page 50.
50.
Yes, Manoj. Is of your lordships, Manoj. This court at page 50.
Your remedy lies only to the Supreme Court.
My lord, that matter is altogether different, my lord. There, my lord, we went on SLP, my lord, to the Supreme Court against the order passed by.
But whatever it is, but even going by that, how can you come against the finding of fact? I think that one judgment of Madras High Court is also there.
Lordships, may kindly have that. I've just got a copy, Manoj. My apologies.
It's not available?
Lordships. Madam, sorry. Here your lordships passed.
I think it's sitting with Justice Saravanan or...
Yes, that's Saravanan. Lordships memory. Lordships. Your lordship is sitting with Justice Saravanan, Lords. There your lordship have given a specific finding saying that tribunal being the final fact-finding authority. Yeah.
What is there? Koshika, we'll dismiss it today.
Mala's request for. Today is the first day, Malad, otherwise.
Today the first day means?
When the last day delay was confirmed, is fixed today.
It doesn't mean that you cannot pass orders.
But only one day. Till tomorrow or any other day, Malad.
You want an auspicious day to face the dismissal.
It's an International Labour Day, my lord, today, so
No, we are working.
any day, my lord. Even for tomorrow, I'm ready, my lord.
He's not available.
Tomorrow, my lord, no, my lord, I have to be in Delhi.
Monday.
Monday,
Come on online.
I'll appear online, my lord. I'll appear online, my lord. I've just submitted this, my lord. I've also filed a reply, also short reply on this point, my lord. Jyoti Limited, the tribunal follows that. Against that, lordship, can you have
I read the tribunal order.
tribunal order, my lords? My lord, can you
Find it in the Times of the
look at Jyoti Limited also, Supreme Court, my lords. Just have a look once, my lord. That's my only submission, my lord, subject to what my friend has to say. Honorable my lord, this is M.R. Shah sitting with Honorable Lord Justice Nagaratna, had passed a detailed judgment. That's at page 40 of the reply which I filed on the last occasion, my lords.
Page 40.
Page 40. I had given this on the last occasion, my lords.
1 minute.
My apology, my lords. Identical issue, because the tribunal follows this judgment in the present case.
And Justice M.R. Shah.
That's the M.R. Shah judgment, my lords. This is against the tribunal. Lordship makes kindly see the first para itself. Feeling aggrieved and dissatisfied with the judgment of the CSTAT, Ahmedabad in order and appeal number so-and-so, where tribunal has allowed the appeals preferred by the respondent assessee and set aside the demand of duty and penalty as per the revision authority. The revenue has preferred these appeals. So one, they went to Supreme Court. They did not come to the High Court, my lords. Second, your lordship may kindly see the factual aspect noted by the Honorable Supreme Court.
Which paragraph?
Lordship may kindly have para 2.2, 2.3 and 4, my lords. 2.2, the commissioner took up the order by way of suo motu revision held the services rendered by the assessee can be said to be rendering service of nature of advice, consultancy, technical assistance while executing the works contract, and therefore they can be said to have been consulting in service, engineer services which were liable to service tax. Then para 4, my lords. Having gone through the order passed by the commissioner confirming demand of service tax, it appears that the commissioner confirmed the demand of service tax merely on the ground that the services rendered by the assessee can be said to be services rendered by consulting engineer and therefore liable to pay service tax. However, considering the various services rendered by the assessee like erection, installation, commissioning of goods at the customer side, incidentally they may also be providing services of drawing, design, etc. It cannot be said that the services rendered by the assessee was a consulting engineer. The contract was said to be a works contract. Hence, the assessee cannot be said to be rendering service of a consulting engineer, therefore not liable to pay service tax. Therefore, once the assessee at the relevant point cannot be considered as consulting engineer or rendering consulting engineer service not liable to service tax on works contract or the contract rendering services consulting engineer for the period under 1997 to 2000. No error has been committed by the order of the tribunal and the tribunal has rendered a finding of fact, my lords. It's identical, absolutely identical, my lords. Nothing is there, my lords, in this appeal, my lords. It's covered by the Supreme Court, my lords. There's nothing.
This Monday,
we do not know. You have to tell us whether we'll be available here on Monday or not.
Monday we may not be available.
Monday?
No, Monday we may not be available.
Oh, that's Monday.
Wednesday, Thursday, my friend can appear online.
We will be back only on Wednesday.
My lord. So Thursday or Friday?
After the inspection.
My lord. So Monday, after that.
You said tomorrow. Why not we have it on 3rd, Friday?
Friday.
3rd.
Friday, my lords. No difficulty.
Friday.
Do we have any camp? Friday. We will post it on Friday.
Friday, my lords.
Yes.
I'll beg to appear from you.
Yes.
My apology, my lords.
So here, the COVID has done bad, has done good also.
Absolutely, certainly, my lords, certainly.
So ever since the introduction of virtual hearing, ensure that it continues.
Certainly, my lord, certainly. Yes. It's only our endeavor to assist your lordships physically, my lord. That's why we have come all the way.
Item number 2.
Grateful. We are obliged.
We, all of us, both of us went and Chief Justice of India's court, first court.
First court, my lords. Yes.
That's complete. There's no paper.
Yeah, my lords, in fact, my lords, when we had entered, my lords, at least in Delhi, with great respect, my lord. I have no shame or calm in admitting this, my lords. Delhi is way ahead of Bombay, my lords. Bombay still we are using paper like us, my lords. Delhi,
because we are accustomed to this.
To this flagging and reading. In fact, my lord, the Honorable Chief Justice Court.
Now you and I can write.
Lordships.
If you ask our children to write, grandchildren to write, they will not be in a position to write.
They will not be in position to write. They'll be in position to type.
They will not be in a position to write.
Lordships.
So now we are moving towards a different era.
Certainly not.
So you are permitted to appear through online.
Lordship, please. Great.
In fact, last Friday we pronounced orders online, virtually.
Virtually, my lord.
Yes.
Great. We are obliged.
Item number 2.
Yeah, please, Your Lordship. Your Lordship, I'm appearing on behalf of the petitioner. Your Lordship, I'm praying for some time. The conducting counsel is indisposed.
What is this, madam? What is the matter about?
It's fixed for hearing for interim. It's fixed for interim hearing.
Interim hearing?
Yes, Your Lordship.
What is an interim hearing?
It's for stay, Your Lordship.
Stay, what is it?
The matter
Against which order?
against the CAT order, Your Lordship.
Central Administrative Tribunal order.
Yes, Lordship.
What is the order passed by the tribunal?
Yes, Lordship.
What is the order passed by the tribunal?
Yes, Lordship. Page 121.
121.
Yes, Lordship.
You are for the?
Petitioner, Your Lordship.
Oh. What is wrong?
The
What is wrong with the tribunal?
Your Lordship, the respondent was arrested on criminal case.
See, the benefit of doubt has been given.
Your Lordship, there is an OM that's stating that the office, page 56, Your Lordship. Para 3, Your Lordship. The 6th line, Your Lordship.
Yes.
He may be promoted notionally with reference to the date of promotion.
Where are you reading, madam?
Para 3, line 6.
In
Your
case the
Lordship.
government servant completely exonerated due to promotion determined so and so. Not possible. However, the cases may, there may be cases pending where disciplinary proceeding a criminal case delayed instead of employee clearance the disciplinary proceeding, the benefit of doubt. This is office memorandum.
Yes, Lordship.
So based on this, so he has been acquitted based on benefit of doubt.
Yes,
He is not entitled to relief.
Yes, Lordship. He appealed to.
That is financial upgradation.
Yes, Lordship.
Is this pertaining to financial upgradation?
Yes, but the areas, Your Lordship, MACP, fall under MACP.
What is the prayer 8.3? Does not want to press 8.3, not related to prayer 8.1 and 2. What is 8.3 prayer? What is the prayer? Yes, sir. What's your case?
Your Lordship, here the respondent was acquitted on the basis of
Benefit of doubt.
benefit of doubt.
But
Your
in
Lordship.
terms of the office memorandum dated 14 September 1992, you are not entitled to a relief.
Your Lordship, actually, the conducting counsel from the petitioner has already intimated my senior so that they will be asking for paying for the time. So,
Whoever is going to come is going to be your order. Whether a senior or junior. This is the office memorandum. This is a force of law. And it's an admitted case that you have been acquitted on the benefit of doubt.
but Your Lordship, however, here the CAT has passed an order to grant the earlier benefits. The
They have,
respondent.
they have
CAT has already passed the order here, Your Lordship.
already passed an order
CAT.
granting benefits.
Yes, Your Lordship.
Where is it?
They have annexed it, Your Lordship.
After the order from the tribunal.
Yes, Your Lordship.
We are appealing for that, Your Lordship. Hence, for the office memorandum, 3. We are appealing for the order of the CAT.
No, order of CAT is at page 121.
Yes,
He
Lordship.
says after the orders of the Central Administrative Tribunal, the petitioner has agreed to grant all the benefits.
Your Lordship,
Has attained the age of superannuation.
Yes, Your Lordship.
no, Your Lordship, I have not attained it.
Where is the paper? If that is the case, we can also close it saying that it cannot be treated as a precedent. Where is the order, sir? If you want relief, give the order. 125.
125, paragraph 10, Your Lordship.
Taking into consideration both the submission and also the ground of opinion of the applicant entitled to benefit of stipulated reflect to the which order? Mr. Counsel, when you cannot ask her, we'll also read and come. But we do not know which paper is in which page. It's a duty of the juniors.
Lordship, the respondent was asking the areas from the pendency of the case, 2014 to 2020. The trial.
That is right.
Yes, Your
See,
Lordship.
once he is acquitted on merits, he is entitled to a benefit.
Yes, Your Lordship.
So, he according to him, the acquittal,
Yes,
either on merit or on benefit of doubt, should be placed on the same footing
Your Lordship.
and should be treated on par, and he is entitled to a benefit. That is his argument. You are relying upon September order saying that in terms of the office memorandum, he is not entitled to, is your case.
Yes, Lord.
It's your case, is it not? He is not entitled to. Where is the order?
Your Lordship, I humbly pray for some accommodation can be may be given to so the senior may come and argue the case.
For this and all, your senior need not come, sir. What is it he is going to do? You have made your submissions. Only thing is, you show us the document that after the orders of the tribunal, the benefits have been extended to you. If that is the case, we will observe that the order of the tribunal is not correct. However, the benefit has been extended, it need not be prevented. That we can do that. Where is that order?
Apologies, Your Lordship, I haven't gone through all the.
Sir, I have been telling from day one, from the day of assumption of an office, of this office, not as a judge of the court. And as a lawyer also, you should tell my juniors. The judge is in the position of a surgeon. You cannot, after surgery, you cannot search for suture. It will be a postmortem. You must understand that. What is the charge against you in the criminal case?
Under IPC 420 and 468, Your Lordship.
What?
Forgery.
Forgery, 471.
Yes, Lordship.
468 and 420.
468.
Forging of a birth certificate, Your Lordship.
Fake documents.
Yes, Lordship.
Lordship.
What is it? What fake document you have produced?
Birth certificate, Your Lordship.
Birth certificate. And you continue in survey.
I deny the allegation, Your Lordship.
That is right. It has been established in inquiry. Fake certificate. Sorry, we'll allow the appeal. Allow the appeal. If you produce the order, we'll incorporate. If you produce the order, we'll give the benefit. The present writ petition has been filed challenging the order dated 3rd February 2023 in original application 043/0019/2022, wherein the tribunal has interfered with the impugned order and directed the writ petitioners to extend all the benefits within a period of 3 months from the date of the communication of the order of the tribunal. According to the applicant in the original application, he was granted MACP with effect from 31/12/22. So you put it as accelerated, all those things. With effect from 31/12/2014 after completion of 10 years, based on the circular dated 19/5/2009, issued by DOP&T. However, the financial upgradation was not given, for which applicant made a representation dated 15/7/2021, which was rejected on 4/8/2021. The reason given by the writ petitioner department was that the applicant in the OE was acquitted from the criminal case based on benefit of doubt, and as there was no honorable acquittal, the applicant would not be entitled to any relief. The department relied upon office memorandum dated so and so, wherein it's para number 3 is extracted below. The petitioner was charged in the criminal case with regard to forgery of birth certificate for an offence under 468 of IPC, wherein in the criminal court he was acquitted based on benefit of doubt. The tribunal has also observed that the respondent, knowing the fact that the applicant, the department were aware of the fact that the applicant was acquitted based on the benefit of doubt and granted MACP with effect from 31/12/2014 and non-granting of arrears on the ground that he was acquitted on benefit of doubt has no relevance in this regard. Full stop. When the petitioner has got the benefit of the circular, one particular circular, the earlier circular, page number 55,
56, Your Lordship. 56.
56, dated 14/9/2022 is equally applicable. And the relevant provision with regard to action after completion of departmental case bar criminal prosecution is extracted supra. When the forgery, but whether any departmental inquiry was conducted?
Yes, Lordship.
No pleading, nothing has been reflected in the.
May I please, Your Lordship? Your Lordship, we may be allowed to file reply, Your Lordship.
No. We are asking for the tribunal. The petition was also in police custody between the not petition. The applicant was also in police custody from 19/6/2012 to 9/7/2012 and subsequently was released on bail. So it's page number 115, sir. He was placed under suspension. The applicant's suspension was revoked with effect from 1/1/2013, pending finalization of criminal case in so and so number. As the department felt that court cases are moving in snail pace. However, on 13/1/2020, in so and so number, the applicant was acquitted on the ground of benefit of doubt. Since the applicant had the benefit of doubt, which was the reason for acquittal, in the light of the Office of Memorandum dated 14 September 2022, the appointing authority has every right to deprive the monetary benefits to the applicant. The applicant was in custody and only after grant of bail on 9/7/2012, the same was intimated to the office on 10/7/2012. But you have not conducted a departmental inquiry. You have not conducted a departmental inquiry.
May I please, Your Lordship? I may be given chance to argue, Your Lordship. I'll do it tomorrow, Your Lordship. I'll prepare it.
So we are completing the judgment. That time you are saying that pay him 118. Admittedly, there is no departmental action initiated.
Your Lordship, page 53, Your Lordship.
53.
Your Lordship, increment which is prior to his.
There was no disciplinary action. Departmental action. There was no departmental action. However, based on the office memorandum extracted supra, the respondent has taken action. Since the appointing authority has a right to deny the arrears of pay in case the departmental proceedings or criminal proceedings is ended in benefit of doubt, the applicant is not entitled to any relief. The tribunal has proceeded on the basis that an order has been passed on 31/12/2014 granting benefits, knowing and the respondent and the petitioner is aware of the fact that the applicant was acquitted on benefit of doubt. So, the substantial justice have got to be done. In the present case, Honor, based on the office memorandum, petitioner is not entitled to any relief, and we have no other option except to interfere with the order of the tribunal, set aside the same. No cost. See, our case relies upon only that 1992 office memorandum. Because based on subsequent office memorandum only, you got promotion. You got, similarly, you want to say this will not be applicable. Suppose this is not applicable, the other office memorandum based on 2014, the benefit based on the office memorandum subsequent only is not also not entitled to.
Objections.
Item number 3.
May I please, Your Lordship? Your Lordship, the Appellate's Counsel, Mr. Rai Chaudhary, he is not well, actually, he could not come today. So,
what is the matter about?
This is a writ appeal. I don't know, on the last occasion, Your Lordship already heard the matter, my lord. This is a matter where a constable shot at the fellow constable, my lord. 3 rounds of bullet.
Oh, yes, we heard the matter. Yes, we want to pronounce order. We'll pronounce orders.
My lord.
3 bullets. Is it not? Knee, thigh, and other places.
Somehow the victim survived, my lord. But he has been.
How can we reinstate him? So you want one more opportunity to finish him off? Yes. Pronounce orders. Orders on. Those for orders on 10th.
My Deep. All right.
Yes.
From the minutes, item number 1.
May I please, Your Lordship, I plea on behalf of the conducting counsel. I plea on behalf of the conducting counsel for adjournment of 1 week as he's indisposed.
What is the matter about?
Your Lordship, the matter is a service matter is regarding termination of service.
Huh?
It's a service matter regarding termination of service.
Termination. On what ground?
Your Lordship, I'm sorry, my apologies, but I do not have the brief as the conducting counsel is from out of station, and I was just instructed.
Read and come. You are a junior counsel on record.
My apologies, Your Lordship, but my only instruction was.
Repeatedly, telling from day one, I am saying, junior must read and argue the matter.
My apologies, Your Lordship.
Who's on the other side? Assam, Moshika was appearing, He's for the, where is he? Assam Rifles. Put it in the scroll. Moshika, Dr. Moshika is expected to be in the first court. Scroll, you can type it in the scroll, no? Scroll is not there. Oh, in Chennai it is there. It will be displayed in all the courts and also the Bar Association. Not in the canteen. You don't know anything about the case?
Your Lordship, I'm not his junior. I was just instructed to pay for adjournment, Your Lordship. I'm not his junior, Your Lordship.
You are appearing before the first court.
Yes, Your Lordship.
The Chief Justice Court, when you are appearing, you should be prepared to make your submissions.
My apologies, Your Lordship.
Tomorrow you may occupy the seat. You will expect same thing from the junior advocates.
Yes, Your Lordship.
Absence from duty. You have been taken to custody for selling ganja. You have been traveling from one sister state to another sister state. 5 years absence. How many years? You say nothing, you don't know anything, what to do. Tomorrow.
Much obliged, Your Lordship.
Tomorrow you read and come. You must give the list of dates.
Yes, Your Lordship.
First date of joining, how many years you have worked, and all those things. We'll ask them whether for the actual services rendered, whether any benefits could be given. Because you have rendered 19 years of service. Dismissal appears to be the capital punishment. You argue, you try to give some relief.
Yes, Your Lordship.
For absence, they have dismissed you from service. Not though other charges are there. You rendered 19, but you have absented for 5 years, which of reinstatement anyway it doesn't arise because you attain the age of superannuation. Tomorrow,
Yes.
be prepared. You have a copy
No, Your
of the
Lordship.
pleadings, papers.
No, Your Lordship. The conducting counsel is from out of station, Your
From
Lordship.
where?
From Guwahati, Your Lordship.
You don't have any papers.
No, Your Lordship. I'm not his junior, Your Lordship.
What is it?
I'm not his junior, Your Lordship. And I was just instructed to pay for some time, Your Lordship.
They ask him to come tomorrow.
Okay.
Moshika, respondent name is printed? Printed. Moshika.
Yes, sir.
Where is he? Yes, tomorrow. Ask him to come.
Yes, Your Lordship.
Somebody who is going to represent him tomorrow must read and come.
Yes, Your Lordship.
Then you don't come.
Yes,
So not his junior, don't come.
yes, Your Lordship.
We'll pass orders based on the records.
Yes, Your Lordship. Okay.
Item number 2.
Much obliged.
Item 2.
May it please your lordship. This is also a service matter, your lordship. This is also a service matter. The petitioner here
Yes,
was dismissed from service
On the ground of? What is
on
the
the
charge?
ground of neglect of duties.
Neglect of duty.
Yes, your lordship.
Absence.
Not absence, your lordship, like
Neglect.
one of the UTP was
Negligence.
escaped from the lockup. So your lordship here,
Who is
like,
being the respondent?
no, respondent was state, your lordship, earlier counsel had been elevated. So now I don't know who
Who
is.
was appearing?
Earlier, previous counsel has been elevated, your lordship, on bench, Honorable Justice B. Bhattacharjee. So
Who was
there are-
appearing?
earlier, yes, your lordship. So now I don't know who is coming.
Ask the inform AG. Ask somebody to represent. The previous case also represented counsel representing the petitioner sought time. There is no representation for the respondent. Here, it is represented by the second case. It is represented by the counsel appearing with the petitioner, that the counsel appearing with the respondent got elevated to the bench, and he is not aware who is representing the respondent now. The registry is directed to inform the Advocate General to depute the counsel to represent the matter tomorrow. Both the cases tomorrow. We'll see tomorrow.
Deeply obliged.
So unless you cooperate, I will not be in a position to dispose of.
Your lordship, I am ready to cooperate.
Not you.
Your lordship.
Both sides should cooperate, you know.
Yes, your lordship. Last date also I appear here, but someone appear and such took time.
Both hands should join when you want to have clap.
Yes, lordship.
You can't have like this.
Yeah. Deeply
You
obliged.
must come. Yes.
Item number 3. Yes, sir.
No representation for both. Somebody is there, madam is there.
May it please your lordship. Lordship, in this item, I am appearing on behalf of V. Kumar. V. Kumar is out of station to Himachal Pradesh as his mother is unwell. She is hospitalized.
You are representing whom, madam?
To the petitioner. And I'm appearing on behalf of V. Kumar.
So I think this is a case where we have heard in detail when Mr. Pathak appeared last time.
Yes, Lordship, but Patrick is on legs in another court.
Will he come?
Lordship, I'm not able to contact him.
Shall we call the matter
He's on
tomorrow?
legs.
Shall we call the matter tomorrow? Because we've already heard and made notes.
Yes, Lordship.
He said that earlier writ petition was dismissed on 15/3/2016, against which there is no writ appeal.
Yes, Lordship.
See, you should have sought for a review of the order or filed an appeal. How is it maintainable, madam? How can you file same relief because other persons have got relief in the writ petition?
Lordship, if the matter can be taken up on some another day.
Tomorrow. Take it tomorrow. Let Mr. Pathak appear.
Okay.
Who's the matter tomorrow? There's no representative of the respondent. This is also motion has appeared. Because in this case, I've already
Obliged, Lordship.
Yes.